morning, everyone. I'm David Freeman Engstrom. I'm a professor at Stanford Law School. I'm also the reporter on the project Principles of the Law, High Volume Civil Adjudication. So thanks to everyone for being here on this third day of this really great 100th anniversary celebration of the ALI. Here's what we're talking about this morning. Many people believe that the civil justice system is on the cusp of some of its most important change, maybe in a century. And there are lots of reasons for that. One is surely COVID, which shook loose a lot of institutional inertia within courts. Another is, I think we could all agree, a clear populist trend in American politics and society. And that's brought a lot of skepticism about institutions and expertise, especially professional expertise. And yes, that includes lawyers. But I think two more forces are arguably playing an even greater role, and they're really at the center of what we're going to talk about this morning. First is the rapid advance of new technologies, and those range from simple Zoom to AI, to artificial intelligence, with ChatGPT just being the most recent chapter in a lot of really incredible advances in AI. The second is what many see as a full-blown access to justice crisis in the state courts in particular. So we have a truly stunning lineup of panelists this morning to talk about technology and access to justice. And I just want to introduce each person very briefly, even if you've read their bios, to underscore just how impressive they are. Becky Sandefur, at my far left, she's a professor at Arizona State University. She leads the T. Denny Sanford School of Social and Family Dynamics. But I think of her as a different kind of dean. I think of her as the dean of Access to Justice Scholars. And I am most certainly not the only person to think so, because the MacArthur Foundation named her a MacArthur Fellow back in 2018 with one of its Genius grants in recognition of her work in access to justice. Moving to the right, Colin is the CEO of Mediate.com and Arbitrate.com, but you can think of him as the dean or maybe a founding father of what's called online dispute resolution, or ODR for short. And in fact, Colin helped build some of the very first ODR systems at eBay and at PayPal, and then more recently built the company Modria.com, which is now part of Tyler Technologies, which serves so many of our state courts. All right, last but certainly not least, just to my left is Bridget McCormack. She recently stepped down after a hugely successful and inspiring run as a justice, and then the Chief Justice of the Michigan Supreme Court. And she is now, as of February, I think, President and CEO of the American Arbitration Association. So let's start in a little bit. I want to start with numbers, some statistics. Here's the first one. In 75% of the roughly 20 million cases, civil cases, filed in state courts each year, so do the math, that's 15 million cases, at least one side lacks a lawyer. And these are really consequential cases for people. These are, by and large, debt collection actions, eviction actions, home foreclosure, mortgage foreclosure actions, and various family law matters. By the way, they also disproportionately affect women and people of color. In case that's not bracing enough, here's a second statistic. The modal case, so the most numerous type of case in the state courts right now, and therefore the most numerous type of case in the American legal system, because state courts are 97% of cases, is a debt collection action with a represented institutional plaintiff, a bank, a credit card company, or a debt buyer, and an unrepresented defendant. That is the modal case currently in the American legal system. So those are the two stats that get trotted out all the time when people say that there is an access to justice problem within the American legal system. And so I'm going to stop talking, and Becky, turn it over to you. You're the dean of access to justice. So how do you think about those statistics, or how do you think about all of this?
Thank you, David, and I want to thank the American Law Institute for bringing this really critical set of issues in front of it. I think it's really important that the legal profession be thinking about how to move forward on these things. I want to take a little bit of a step back from the statistics that David gave us, which were about things that are going on in courts. And I want to make an observation that law and justice are not the same thing. And there are lots of ways in which we might approach that observation. I mean it in a very specific way, which is, if you think about, this is a democracy, the reason we have laws, I learned as a child, was because there are some activities that are so important, like making a living or taking care of people who are dependent, that we should have a collective stake in ordering how those activities go. It's that important. So for example, if you're a landlord, you can't just decide you don't like your tenant and throw them out. We have rules about how to do that and when it's appropriate and so on. We have rules about, as David pointed out, debt claims are a really prominent part of state court dockets. If David thinks that I owe him money, he can't just come and take it. There are rules about how he can access that and where he can get it from, and because my ability to still make a living and fulfill my other obligations is an important part of what we're trying to order. So in that context, what we want, if we're thinking about access to justice, is the lawful or just resolution of the many millions of conflicts that Americans will have every year that are governed by the law. So the 20 million state court cases that David mentioned are the tip of an enormous iceberg of 150 million to 250 million new civil justice issues that Americans at all income levels, of all races, of all genders and sexual identities will experience every year. So when we're thinking about access to justice, we're thinking about courts and lawyers in a traditional way, but we're also thinking about other ways in which we might get people and those problems to just resolutions. I want to make one other connection to a point that David made. So we want just resolution, and we want it to be widely accessible, but we also want it to be equally accessible. And what David is describing in the example of debt collection cases where an institutional plaintiff who is in court a lot and has lawyers who are in court a lot is facing an individual plaintiff who may never be in court ever again in their entire lives, and often doesn't have an attorney, there's a significant power imbalance there. There are different economic resources of those two parties. There are different expertise resources of those two parties. And it's important to think about the role the legal system either can or could play in making that an actually level playing field.
Thanks, Becky. All right, so that's the problem we're up against. That gives you a sense of the state of civil justice, especially in those state courts. You all can imagine that in this day and age, there are lots of folks who are proposing technology as a possible way to address the situation. You all probably know that Zoom hearings became quite pervasive during the pandemic. That was one of the really important tectonic changes in the court system that I think COVID wrought. Colin, you've spent your career going all the way back to those eBay and PayPal days working on something that's more than just Zoom court. It's more than just a remote hearing that looks a lot like a court hearing, but online, and that, of course, is online dispute resolution, or ODR. So I'm wondering if you could tell us a little more about that. For instance, like where has it been, where is it now, and maybe importantly, since this is kind of a future-directed panel, like where do you think it's going?
Absolutely. Thank you so much, David. Online dispute resolution is just dispute resolution plus technology. So many of you have heard about ADR, alternative dispute resolution, things like mediation and arbitration. Well, online dispute resolution is just traditional dispute resolution accelerated by technology, and really it came out of e-commerce. It was when the internet started to expand in the mid-90s. I was working at Mediate.com even back then, and the whole question was, well, how are we going to resolve these disputes? You know, if you have a buyer that's in Argentina and a seller in France, and the marketplace is in California, and the item is being drop-shipped out of China, and the average value of the dispute is $75, you know, which lawyer is going to take that case? Where are the billable hours? Who's going to resolve the jurisdictional issues? So the large internet intermediaries, eBay in particular at the time, said, well, I think we have to build kind of a new justice system that works for these kinds of cases. So they hired me in 2003, and we built something called the Resolution Center. Now, by the time I left eBay in 2011, we were resolving 60 million disputes per year. And we were resolving 90% of those without a human from eBay having to touch the case. And 50% of those cases we were resolving via mutual agreement, meaning the buyer and the seller went through a software-based process to reach a solution by mutual acceptance. So I think the challenge was the e-commerce companies had to find a way to establish trust in the marketplaces because nobody knew what e-commerce was. So they needed to have fast and fair resolutions. And what we realized is these resolutions couldn't take weeks. They couldn't take weeks. They couldn't take months. They couldn't take years. We needed to resolve these cases in hours. And we found actually that our disputants at eBay would rather lose their dispute quickly than win their dispute and have it take a long period of time. And that long period of time was 12 days. If the dispute took longer than 12 days, people would rather have lost on day one. Again, because you're talking about a relatively small amount of money. But the reality is the judicial system was irrelevant for these cases. And eBay, I left in 2011. eBay's probably 2 or 3 times larger than that, and I bet Amazon is 3 to 5 times larger than eBay, and now Alibaba in China is 3 to 5 times larger than Amazon. So these types of disputes, these cross-border, high-volume, low-value disputes, are growing at about 16% per year. And the judicial system is too tied to geography. It's too tied to where somebody lives to figure out how to resolve these cases. So that was really the origin of online dispute resolution. But once we proved that we could resolve these kinds of case volumes at that volume, other institutions started to be very interested in online dispute resolution. So we've seen a flowering of ODR around the world. Actually, the United States is a little bit behind the curve. I was just in India for our recent ODR forum, and many of you know civil cases, the average time to resolve a civil case in India is somewhere north of 13 years. So they are embracing an entirely new justice system based on ODR to resolve all their digital payment disputes, and the government is rapidly eliminating paper currency so that everything's going to be a digital payment soon. So what we see is ODR is expanding to other areas, and we're going to talk about some of its early application in the court system because that started to take root in the US and around the world. But I think fundamentally it's not really about where we are now, it's about where we're going. And online dispute resolution started out looking like face-to-face dispute resolution, but it's changed a lot because we have a lot of powerful tools in the toolbox. I know we had a great panel yesterday talking about artificial intelligence. Well, this is an exciting new tool in the ODR toolbox. But if we're going to tackle some of the issues that Becky's talking about, and again, I'm not a lawyer. I think Becky's not either. I'm what they call an NLM, a non-lawyer mediator. I kind of think about these problems in a slightly different way. How can we maximize fast and fair resolutions for as many people around the world for the resources that we have to expend? So I'm sure we're going to talk further, but that's a good start, David.
So Colin, I want to ask a quick follow-up because you mentioned something right at the end there that I think is really important. So Zoom court is synchronous. Both parties there present. It looks a lot like a court proceeding. But
Sure.
ODR is actually asynchronous. So the parties come on when they need to make a submission or make a settlement offer or what have you. You know, I think of this in terms of generations of ODR. So you can think of ODR, you know, call it ODR 1.0. That's just a gathering place. It's an asynchronous gathering place where the two parties can get together and try to bargain their way to a settlement. But you started to talk about technologies, and I'd love to hear a little bit more about that, just to kind of level set and let people understand what's going on. Because my understanding is that ODR has begun to prime the disputants with some information.
That's right.
Or maybe set up a little bargaining system. There are divorce tools where the parties can prioritize particular property, and then the system actually sends back a settlement package that makes sense. So we're priming disputants increasingly with information, and it may be someday that we could actually arm the disputants with a prediction as to how their case would come out if it was litigated to a judgment in court. Can you talk a little bit about generations? Like, where is this going? That's like the future-looking question. What's
I will
possible,
say, David,
do you think?
I'm anticipating the reaction from the audience here, and your framing is a little fraught. You know, the notion that technology can somehow prime the disputants to have an idea of what a fair resolution is, that starts to get into, wait a minute, okay, are the algorithms sort of taking over the role of the lawyer? I will be very clear. It was interesting, you mentioned before my company, Modria, was acquired by Tyler, which is sort of the Microsoft of court tech. I'm sure many people here have used Tyler's product like Guide and File and Odyssey. But I never wanted to sell ODR to the courts. I mean, I'll be perfectly frank with you. I wanted to buy bulletin boards outside of every court in the United States that said, don't go in there, come to ODR.com. To me, it's much more interesting to prevent people from going to court than to try and utilize these tools in the litigated case, because there's a lot of, and of course, this gets to Becky's point too, the vast, vast majority of cases, of disputes that exist in the United States on an annual basis never see the steps of the courthouse. So obviously, there is a lot of tension around, even within a courthouse, nobody wants to give legal advice because they know they're going to get in trouble. So if you go to the clerk and say, what file should I form? We have 75% of these pro se litigants. You go to the courthouse, nobody's going to give you any help because they're so worried about getting in trouble. However, we in the dispute resolution field, if we can get cases before they become litigated, well, there's a lot that you can do to sort of frame. Now, you asked about the evolution of ODR technology. I will say at eBay, we were an asynchronous marketplace. At least until Meg Whitman bought Skype, and then we had to throw some synchronous in there. But primarily, it was people who logged in at their leisure, and they would see, okay, what items are available for purchase, and I have these bids that are outstanding. So we communicated with our parties asynchronously. And there's a lot of very interesting advantages in the dispute resolution process when people can respond when they like. You can actually get a little bit of cooling distance. You can manage escalation. People can be a little bit more thoughtful and reflective in the way that they participate. Now, I always joke that Zoom is the gateway drug to ODR, and a lot of, forgive me, Bridget, a lot of arbitrators, who are very comfortable with face-to-face mediators, who are comfortable with face-to-face practice, well, Zoom's not that big a leap, right? Instead of meeting in a conference room at the law firm, well, we'll just get on Zoom, we can do the same thing. Now, I will point out that video conference is not the same thing as face-to-face, and there are some significant changes in the way the process works, but it's not that big of a leap for a practitioner. But now we're starting to see, again, the National Center for State Courts defined ODR as an online collaborative workspace where the parties can convene to resolve their dispute or case. And to me, that's a far too narrow definition of what ODR can be, because it eliminates the role of what we call the fourth party. So if you think of party 1 and party 2 are the disputants, party 3 is the human neutral, that could be a judge, an arbitrator, or a mediator. Technology is the fourth party, and it also has a seat at the table. And there's a lot of things we ask technology to do today, send out our reminders, manage our documents, things like that, manage our payments, but none of that's controversial. But the question is, what will the fourth party do tomorrow? When we have AGI, when we have advanced artificial intelligence, maybe we will ask the algorithm, what do you think a fair resolution of this case would be? Or what would be a range of appropriate settlements? Or what's my BATNA? What's my best alternative to a negotiated agreement? What's my worst alternative to a negotiated agreement? These are kinds of things that now AI has the potential of providing in a dispute resolution process. And I think that that's a reasonable thing for parties to have access to when they enter a process. Now, some people take it all the way to we're going to have digital arbitrators and mediators. I don't think that's happening in the near term. I think what's going to happen is we're going to have these high-powered AI assistants that are going to help us become superheroes. We're going to have powers we never had before. But this is, again, adding to the ODR toolbox, and we need to figure out what the future of fast and fair resolutions look like with the tools at our disposal.
Great. Superheroes provides a perfect segue here. So, we clearly need to get Bridget involved here. Colin, all due respect, you're an NLM, and you're the worst kind of NLM. You're a Silicon Valley NLM. So what I think we need is...
Tell me what you really think, David. Yeah.
We need a voice to kind of bring us down to earth, maybe. So maybe I'll turn to Bridget, right? You just stepped down as Chief Justice in Michigan. You presided over a very large court system. You also presided over a court system that was thought to be among the most innovative during COVID. So I just love to hear from you. You've heard this kind of futurist vision, but let's talk a little bit about the state of technology in state courts and what some of the challenges, high or low, that you faced when you were running those Michigan courts.
Yeah, thank you. Thank you for the question. Thank you for having this panel. I think this is such an important discussion for the ALI to be having. So I'm really grateful that we're having it. I will tell you, when you invited me to be part of the panel, David, I think it was before even GPT-3 was released, and everything changed, and I find myself every morning and every night thinking about exactly what Colin is talking about. And I will tell you, the American Arbitration Association has gazillions of data that we've never licensed. So we have a lot of possibilities in Colin's world. So I do spend my time thinking about it, but I'm going to answer your actual question, which is what courts can do and what some of the barriers are. As many of you know, COVID, the pandemic did give us an opportunity to innovate and try new things quickly and see which ones worked, and many courts did that. Michigan did, but frankly, I think Chief Justice Hecht is in the room, and Texas was a national leader in what they got done, and there were many other states that also figured out how to do things differently and better. In Michigan, we were able to quickly move courts online because our judges already had Zoom licenses, because that's how forward-thinking we were. No, it's not because of that. It's because Michigan's just huge geographically, and we thought Zoom licenses might make sense for some of the things people need to do in courts. Even before there was a pandemic, nobody used them, nobody even knew how to use them, but at least they had them, and we could quickly stand up courts online. But that's different than online courts. We also, though, right before the pandemic, stood up an asynchronous ODR platform in 17 of Michigan's 83 counties, with a plan to iterate and learn from it in those 17 counties before we stood it up statewide. That changed, and we just stood it up statewide in a few months, so that everybody had an option for resolving disputes without going to court. It's absolutely free. It is asynchronous. You can choose to do it with a mediator or without. It seems like it should be a brilliant way to help courts with this massive amount of cases, and maybe even the cases that don't make it to the courthouse steps, that I couldn't agree more with Becky, are as much of a problem as those that do, because there's this tool, but I think we should have done the billboards, because we'll get to it later, but the take-up has been quite slow. But that was, there was a lot to be proud of. I think that we definitely got more done in about 18 months than in about, 7 or 8 centuries. Not joking, I wish I was joking. But the barriers are significant for state courts in really making a substantial change in addressing the massive number of civil justice problems that people have to navigate without lawyers. We're never going to lawyer our way out of the problem, so some of these other solutions are promising, but really hard for public justice systems for reasons that you know. One is politics. Courts depend on public funding to be able to stand up solutions for these kinds of problems. And public funding is really tricky. I spent a good amount of my time on my budget every year in like one-on-one meetings with legislators, figuring out which judge in a certain county could call Representative so-and-so and tell him how important our Justice for All initiative is. So we got that extra vote to get that, $3 million more across the finish line. And it, largely was successful, but to a point, right? To a point, there is a public funding and politics problem in courts being able to transform what they do. On top of that, multi-member courts, which is what state Supreme Courts are, and state Supreme Courts are the ones that are constitutionally administratively charged with meting out justice across the state. These are multi-member bodies, and not everybody agrees about the way we can address the problems Becky described. And so sometimes one of your colleagues can hold you up for many months on an administrative advancement because he's writing a dissent. And you have to wait forever for him to write a dissent, because that's how multi-member courts function, and we can't steamroll people. And then he writes the dissent, 9 months later, and we're already 9 months behind, and then you have to respond to it because the public has to understand how crazy this is. And now it's another 6 weeks, and then he has to revise. So you see my point. There are some inefficiencies that are built into multi-member courts on purpose, right, for our decision-making work, for our decision-making function. I think those inefficiencies are there for a reason. They slow us down. They allow us to hear from one another. That's important when we're making decisions that will set a rule of law for a big state like Michigan. But Michigan adjudicates between 3 and 4 million cases a year, and most of them are in the district court, and most of them are people who don't have lawyers. And we have enormous problems that inefficiency in the decision-making role makes it much harder in the administrative role. I want to add one more problem, and that's the public's confidence in courts, which is on the decline. not just the federal courts, although you are leading the way, federal judges, but also the state courts. And the National Center for State Courts tracks that. And if the public doesn't have confidence in the work we're doing, that we're going to be able to provide them solutions, that is yet another barrier to courts substantially answering this call. I could say more, but I'm going to stop.
Great. Okay. All right. Let's be good lawyers here. Let's stipulate something. Let's stipulate that ODR is necessary. Like some version of tech-fired proceedings is necessary given the amounts, like the huge amounts of unmet civil legal need. And let's start thinking about how we actually go about it and what some of the problems or concerns might be. It's pretty clear, to me at least, that courts themselves aren't going to design these things. And that might go way beyond the multi-member problem. That's just the fact that courts don't have a ton of technical capacity. It's kind of shocking how many state courts can't provide really basic descriptive statistics, what we would call descriptive statistics about their case flows. Like their basic data capacities are actually surprisingly low. What this means, I think, is that courts aren't going to make these new systems. They're going to buy them, right? In that classic make or buy decision, they're going to buy them. And they're going to buy them from Colin, it sounds like. And so that raises an interesting question, and it's not about politics or public funding, although maybe that's part of it. It's about basic oversight, right? You're turning over public institutions to Colin, and then we're going to try to exercise some oversight in how they're designed and implemented. And so I guess, just to start stirring the pot a little bit, like, who's going to watch Colin and how? And then Colin, for you, how do we watch you?
Watch me, here it comes. Actually, it's funny, David said to me before the panel, he said, I want you to be the running dog capitalist on the panel. So I'm about to give you a cold dose of Silicon Valley here, so prepare yourselves. I will say I do have a legal services hat, and that makes me, respect Becky and all the great work that she's done. When I attend a lot of these meetings, the Legal Service Bureau employees are the folks that my heart goes most out to. My background's in public policy. But let me take that hat off, and I'm going to put on the Silicon Valley hat, which is really the law is a monopoly, okay? And this is probably not a surprise to many of you. Most of the industries in our society have been disrupted by technology. If you think about entertainment, if you think about medicine, if you think about finance, those industries are unrecognizable to what they looked like in the 1980s. But the law has held on. Now, why is that the case? Why is it that things, yeah, we have LexisNexis, we have e-filing around the margins, but fundamentally the law has been able to hold out. And that's because if I'm in small claims court and I'm getting bad service, I can't go to another small claims court. There is only one small claims court. And that lack of competitive pressure has created an environment that has enabled the law to not innovate at the pace of wider society. Now, my good friend Shannon Salter, who is now, I think, Deputy AG in British Columbia, but she used to run the Civil Resolution Tribunal, which I think is the most wired court in North America. They've done the best job bringing technology into the judicial process. She often says at meetings like this, if you have a job based on inefficiency, you should not have that job. So how many people in this room do you think have a job where inefficiency is part of your job? Do you think you could make your job, if you had the ability on a blank piece of paper to redesign your process, could you design a system that was more efficient? And that is what the marketplace does. The marketplace finds inefficiency and it eliminates that inefficiency. Now, what I'm thinking is, as society is digitizing, the expectations of citizens are going along a certain vector. And the courts are not innovating at that same rate. So that means every day the gap between the expectations of citizens and the reality of the judicial system is widening. And that creates what we call an opportunity for a disruption, if any of you have read your Clayton Christensen. And what that means is, at some point, those parties are going to find an alternative that better meets their needs. Now, I'm not saying that what we built at eBay is appropriate for a criminal case. I don't think that that's the case. We have to invent a new system that works. But the judicial system is not innovating fast enough. And the Silicon Valley, again, wearing that hat, my running dog capitalist hat, is that this disruption is coming. Now, why is it that everyone is talking about ChatGPT? Well, most of the technological innovations in the past have not really threatened the core value prop of judges and lawyers. But now we're logging into ChatGPT, and this algorithm that nobody trained, it just took a snapshot of the internet and educated itself, guess what? It passes the bar exam. It can do pretty well on generating the kinds of things that lawyers have paid handsomely to have services that lawyers have been paid handsomely to provide in the past. So suddenly you have people saying, whoa, maybe this technological disruption is getting a little close to home. So I am not up here to say I'm going to take away all your cases. I'm happy to wear the hat of Silicon Valley, but I'm just saying this is not a sustainable situation. And as society digitizes, we need to build a justice system that can work the way the internet works. And if the innovation doesn't occur fast enough within the monopoly, eventually the cracks in the dam will break. And so how about that for stirring the pot, David?
Becky, do you want to say who's going to watch Colin, or you want me to go? Okay. So first of all, I couldn't agree more with with this, someone, I think you told me this, Colin, the black swan moment that generative AI is for the profession. Not only did GPT-4 in March pass the bar exam, by the way, GPT-3 in November did not pass, it only passed contracts and torts, whatever that tells you about contracts and torts. But in March, 2.5 months later, it not only passed the bar exam, it scored in the top 10%, and it did it in 6 minutes. So this is it. This is definitely a moment of change, and what we do to respond to it is what I think we all should be thinking about. But I don't think it has to be the courts or Colin. It could be the courts and Colin. And Colin, I'm just using you as a metaphor.
Happy to be employed as such.
Yeah. It is not only the case that the courts can only buy, and it's not only the case that they have to either outsource it or just keep being inefficient. An innovative court system could partner with a private technology company, and we did that a lot in Michigan, and it is how we built the most innovative things that we did. We definitely couldn't have done it on our own, but it definitely helped when we partnered with private technology companies. That doesn't exactly answer your question about who watches the technology, David, but I guess I want to ask you back, who's watching the public justice system in debt collection cases? Because I know you know about those dockets, and I know you know that many of the debts that are litigated in those dockets are the ownership of them can't be proven. The service and the notice often can't be proven, but there's no lawyer to challenge any of those things, so they just end in defaults. So I guess if it were the case that our courts were sufficiently watched, I might spend a lot more time worrying about how we could make sure that our technology solutions were transparent and accessible. I would spend a lot more time on that question. But right now, I don't think we're doing such a great job watching our public dockets.
So since Colin very graciously represented all of capitalism, I'm going to represent all of people. I'm the person here today to talk about people.
Corporations are people. No.
That's one for you.
Sorry.
So Bridget's absolutely right that court systems are not very accountable for what they do, in part because they have a monopoly on doing a lot of it, in part because they're very opaque. They don't keep good records. When you try to get those records, when you try to get public records out of a court system, give that a try. You have to get the special judge who wants to be your special friend to help them with their special project, get the clerk to let you in the special room with a special scanner, right? I mean, there's a lot of probably not lawful restrictions on access to information about what goes on in our public justice system. So that critique of the public justice system is absolutely correct. And it doesn't have incentives to be accountable. The question is, does Colin, who's now representing all of capitalism, have incentives to be accountable? Because Colin is not innovating because he loves justice. Colin is innovating because he can make money. So his incentives to do what he does will pull towards being able to make money. So you will then have a market for justice solutions that has two different behemoth actors, both of whose interests are not mine. Not mine as a citizen who wants to use a public democratic justice system. So then the question is, what kind of structure, system, regulation, regulator could bring my interests into that picture? And so if I'm thinking about my interests, I would like transparency. I would like some autonomy of choice, right? Which right now I don't have. Buy something on the internet and see how many legal rights you sign away by clicking the terms and conditions. Buy that same thing at the grocery store and you don't. Isn't that a little strange, right? So some informed consent and autonomy. And I would like us to think about, going back to that point in David's example of debt collection, the balance of power between different kinds of parties. So there's a crazy country, it's called England. And it has some crazy systems. So it has regulated industries just as the United States does, and many of them have an ombudsman. So there's a telecommunications ombudsman and a financial services ombudsman. And an ombudsman, unlike in a US system, is somebody you go to complain and they cool out your complaint. Sorry, that sucks. A UK ombudsman is independently authorized to investigate your claim against your telecommunications provider, against your bank, against your pension, to make an authoritative ruling about whether you owe them money or they owe you money. And that ruling is binding on the regulated entity, but not on the consumer. The consumer still has the right to take that dispute to the court system. There are ways to design, we could imagine, ways to design this ecology that would be more fair and more accessible than what we have now. But Colin's, as a running dog, runs really fast. And so we need to, start catching up with him.
Well, let me just say, again, as a representation of capitalism, let me pull out a little Adam Smith here, which is one of the things I care a lot about as a capitalist is customers. I care about delighting my customers. And the way that my services as a private provider improve is I'm subject to competition. So if I'm not servicing my customer well enough, they will find another provider. I speak from experience because at eBay didn't do a very good job taking care of customers in the early days, and Jeff Bezos came in and ate our lunch. And now eBay is great for buying Hummel figurines, but if you're going to buy an HD TV, you go straight to Amazon. And if you look at trusted institutions in society, many of these internet consumer brands are more trusted than DC and the judiciary. I mean, look at the numbers. I saw them on CNN this morning. And that's not doing so great. And that's not to say there aren't financial incentives also within the legal system. But unfortunately, many of the financial incentives are set up at odds with the clients. I mean, the billable hour, it's well documented. A lot of people don't trust their lawyers because the lawyer has an incentive for the case to continue endlessly. The other thing I want to emphasize is what Bridget said. The future is not about money. The future is about data. Why is it that Facebook won't take your money? Because you're paying them with your data. And the data is more valuable in the long run. We, in the private sector, again, wearing my capitalist hat, we want that data because the data is measurable. The data is measurable. And one of the things that's frustrating, I think, about the existing system is the lack of data. Data, from my perspective, leads to accountability. People are very worried about bias in the future of a decentralized justice system where, like Larry Lessig says, the code is the law. And it's not about the nation state using its power to enforce outcomes, with judges and laws and jails and contracts. We can write smart contracts and put them in the blockchain and they're self-administering. So it's almost like a vision of the future of justice where we can get fast and fair resolutions where we don't need to have lawyers and judges because everything's going to be self-enforcing. So the question that I have is, what are the financial incentives? And where is that data? Because if I can get data and I can look at a system, I can improve it. And if there is bias in the system, if everything is quantified and we can look at the data, we can find where the bias lives and we can eliminate it. One of the things another metric that you didn't say, David, about the justice system, and this has been well documented over decades, is that people of color get 30% worse outcomes from the judicial system than white people. Well, where is that bias? Where does that live? Where can I go to fix that problem? I don't know. I can't find it. It's an implicit bias in many of the actors within the system. But if I can quantify it and put it in data, I can find that and I can improve it. Richard Susskind, I think we're going to talk about him a little bit. He talks about 50% of people in the world don't have meaningful access to a justice system. If we say that access to justice is synonymous with access to lawyers, we're never going to move that number. But if we start to think outside the box and leverage the power of these technologies, we can think about a step function improvement where we can expand fast and fair redress to a huge swath of people that don't have meaningful access and that are prevented from getting access to justice through things like geography. So we need to be creative and think outside the box to solve these problems. We can't only use the old solutions and say that that's going to be our path to where we need to go.
All right, let's go another round on transparency. I'm a law professor, so let me risk of putting too academic a gloss on all of this. Let me lay out something. I think I hear you saying a very particular thing here, but let me just make sure. All right, so here's the academic gloss. So Professor Owen Fiss at Yale, he writes a famous article back in the 1980s titled Against Settlement. And at the time, he was trying to buck the trend against managerial judging, against a set of civil procedure rules that seemed more geared towards settlement than towards adjudication. And he basically said, it's a very strong form of an argument, but he said, look, adjudication is not about dispute resolution. It's about the elaboration of legal norms and public values. That's what it's about. And so we should worry about a system that moves away from adjudication proceedings, court judgments issued through a process of reason giving, and handing over a whole system to settlement behind digital walls, which is what ODR might be. All right, that's one academic gloss. Second academic gloss comes from Richard Susskind. He's a UK law professor, works a bunch with the UK courts, and he's kind of the chief evangelist of online courts and ODR in particular. And he says, look, we should love these things. We should love these things because they lower participation costs, and therefore they have a huge access to justice benefit. He also thinks it's more transparent, and that's what I hear you saying, Colin. He thinks, sure, we lose what he calls case-level transparency. We lose, court-issued judgments backed by reason giving. We have to turn that over maybe to an algorithm that only Colin really understands. We lose case-level transparency, but we gain what he calls system-level transparency, which is to say, ODR and all the digitization that goes along with it actually allows us to collect data and maybe understand where bias is present in the system, or helps us to understand what the throughput of the system looks like. So who's right? Those are two grand ideas. This notion that the legal system is largely about the elaboration of legal norms and largely about the elaboration and the articulation of public values, as against a claim about data transparency. Is that a good bargain, do you think?
Can I start?
Please.
I think Owen Fiss might have been right in 1810 and maybe even in 1980. And Richard Susskind is absolutely right today. And also, it doesn't have to be either. It could be both, right? I mean, but the problem of the massive number of people who don't have the help of lawyers to address their civil justice problems is relatively a modern problem. I mean, we don't have great data for all the reasons you've heard. Courts are really opaque. They don't keep great data. That might be not a bug, but a feature. But as far as we can tell, it really started to be a problem in the 1990s and has grown significantly, and Becky will correct me on my history, in the last 20 or 30 years. The modern legal system that I think did a nice job with publicly elaborating legal norms and public values was one built by lawyers for lawyers at a time when everyone had a lawyer, and that's just not what we have anymore. And so it's not good enough to provide the kind of transparency that, frankly, data can provide. Data can tell us something, and an ODR system run well can collect the data that you want it to and make that data transparent if you want it to. And it can tell us probably more about legal norms and legal values and what upstream solutions we might want to put into place in a way courts simply can't do right now. I mean, maybe some court will be able to. Maybe there'll be some state that decides we should send a bunch of funding. I think every state should. But for now, state courts are not set up to collect the kind of information that would allow us to figure out what those legal norms and public values are. So Susskind's right today, FIS was right before.
I would love to know the following statistic. What proportion of cases involving ordinary people in state courts make any law at all, or actually result in a decision that a human being could see and read, right? I mean, it's not that, certainly some of them do, but most routine litigation is not leading to this fishistic? I don't know. Fishistic, this fishistic statistic. So I don't think that, to go back to Colin's and Bridget's points about data, why would we lose case level transparency? A computer can tell me how it made the decision. It can tell me the data that it looked at. It can tell me where I changed my mind and where I changed my mind back. I mean, there are all kinds of information that it's much easier for that kind of interface to collect. I think the thing that I think about when I imagine replacing all of you with a robot is right now, ODR is fairly text-based. And right now in the United States, 1 in 6 adults is basically functionally illiterate. So that means that they're not going to be able to express themselves in writing in that interface, and they're not going to be able to understand the information that's coming to them. And that seems like an inequality that we should worry about. And there are other kinds of things like that that aren't about transparency, per se, but that I would want to try to find a way to work with if we're going to start making this an important portal through which people access justice.
Should we worry that ODR is going to make things worse? Like, that's what you're starting to get at there. So there's at least some evidence that that ODR will largely be about compliance, not about adjudication. You know, the uses that are in place include, like in Ohio, it's being used so that local governments can collect fines and fees and back taxes. In the debt collection context where it's used in Utah or in Arizona, it's largely just a way to, you know, to basically manufacture a wage garnishment. There isn't a ton of pushback there. There isn't any sort of thick, you know, litigation of the sort that we might expect, or even thick negotiation of the sort we would want on a platform that's supposed to provide a bargaining space. The most rigorous study of ODR in Utah, where ODR is mandatory, it's more or less mandatory. It's an opt-out system for debt collection claims only. The best study of ODR found that ODR sped up the time to resolution. It shortened cases by 5 weeks relative to conventional adjudication. But it produced no change in the rate of default judgment or in the settlement rate. And so the question is, you know, should we worry about the railroading concern? Should we worry that ODR is just a way to assembly line the manufacture of wage garnishments?
Yes, we should. We should worry about that a lot. It's not that hard to imagine a private provider creating a kangaroo court, you know, where they say to a consumer, yeah, come in, we'll help you with your debt issue, you know, let us know about your landlord-tenant case. And then they collect all the information, and then secretly they share it with the landlord association, or share it with the business. Or maybe you were talking before about, you know, setting expectations for the parties. Maybe they say, you know, maybe the tenant is actually, they have the right to stay in the property, but maybe this website is set up to say, well, you don't have the right, you know, you're not going to get anything more than $100, you know, you better get ready to leave. It's very easy to imagine in an unregulated space bad actors like that. And as the CEO of ODR.com, I will tell you, I'm the #1 enemy of bad ODR, because it's bad for us, it's bad for the dispute resolution field, it's bad, and we are doing a lot of self-regulation within the industry. We have a website called ICODER, the International Council for Online Dispute Resolution, much like the ALI, and we've come up with standards of practice, and people audit against those standards, and you say, I'm going to follow these practices, and you need to be held accountable against those practices. Now, again, the guardrails are not as strong as what we have in the public justice system, but that means we need to have better guardrails. But, you know, those statistics, I will say, I've been involved in a lot of these court ODR rollouts, and I've been a little disappointed by what has happened. Now, I know Dino Himonis, I like the Utah process, I think their heart was in the right place, but really, they just had their internal IT team add a chat room to, the small claims flow, and okay, well, that's ODR. I mean, again, I love the me-resolve process. I love Doug, I love Michelle. There's a lot of great work that's happened in Michigan, but these are wildly underfunded. I mean, if you think about just hiring a company like Matterhorn to come in and build you a system, you pay them a couple $100s per month and say, okay, well, now we have an ODR process. eBay spent tens of millions of dollars building its process over time. And the other thing about software is it's never right when you launch it right out of the box. You've got to refine it. You've got to improve it. You've got to look at the data. That's why I say look at the Civil Resolution Tribunal. Look at these counties that are actually sharing public data on a weekly, monthly basis so they can get better and better and better. So what I would say is all of our society is digitizing. The courts are going to digitize too. And the successes or failures of these initial projects shouldn't indict the overall experiment. I think it means we just have more work to do. We are the systems designers, and we have a lot of refinement to do in making and investing in these systems. But I think bad ODR is a huge potential problem, and we need to be cognizant of it out of the gate.
What does that refinement look like? Like, if we're worried that defendants are going to be railroaded within this system, then we need some kind of closure rule, perhaps. Maybe we need judge approval of settlements. Maybe we need some ability of the defendant to essentially renege, like within 72 hours of entering a settlement. That might be especially important if we have very unsophisticated defendants, 1 in 6 who are functionally illiterate. What are some of those design features then? These are all really grave concerns. So let's talk brass tacks. Like, what are some of the things you would want to see imported or incorporated into one of these systems to try to make them fundamentally fair?
I mean, so I teach at Arizona State University, which wants to scale college education infinitely. And so we do it by putting it online. And we're constantly concerned about the quality of the instruction that we provide and the quality of the education that students get, because it's tricky. So in the Netherlands, they rolled out an online divorce platform separating together called Rechtswijzer. And at the end, it produced a settlement between the two parties that a judge looked at. The tricky thing is scaling that. So if Bridget then, when she's a judge, has to look at 200,000 settlement agreements with her eyes and decide whether or not they're fair, I'm not saying it's impossible. I'm saying thinking about how to do this is going to require the greatest minds of a generation starting now.
And it's also going to require some collective action that I worry a little bit our profession is not great at. I think we have the minds. I think we know what the guardrails could look like. But I worry a little bit about our ability to do things collectively. I mean, America's bad at collective action right now. And lawyers are especially bad at collective action, right? The ALI is like one counterexample to that in our profession. When the ALI was founded, it was a true moment of collective action where the profession said, we have to respond to all this different developing law in all these different jurisdictions. And we did together. But for the most part, the one-to-one model we're taught in law schools, and then lots of other, I think, cultural and normative features of our profession make us not necessarily great at collective action. And that might mean that, Colin gets to decide, right? Like right now, I mean, it's the same question going on in generative AI. Right now, even Sam Altman is at Congress saying, please regulate us. We want the body politic we want the public to weigh in on what the guardrails should be. But does anybody feel confident that the Congress is going to catch up with Sam Altman? Because I don't.
Maybe I could just say one more thing on that point, David. I present to lots of bar associations. I teach in law schools, and the question I get over and over again is, does this mean I'm not going to have a job? Does this mean? And what I will say is, if you want to know what's going to happen to the law, look to finance, okay? If you think about finance 30 years ago, there were a lot of people whose job it was to stand on the floor of stock exchanges with pieces of paper saying, who wants to buy 1,000 shares of IBM? Guess what? All those jobs are gone. They don't exist anymore. Those trading floors have been replaced with the whir of the fans of the mainframes doing these transactions in milliseconds. But there are more people working in the finance sector than ever before. And what are they doing? Well, they're sitting in cubes and they're giving instructions to those mainframes. They're doing those transactions. And I think that's going to happen to the law as well. I think there are going to be some jobs, and again, none of the white shoe firms need to fear. Those cases are not going anywhere. This is going to happen at the low, low level. I used to get the unauthorized practice of law letters from the bar when I started to tackle the high dollar value cases. So I went down. I went to the $75 cases. No UPL letters, which is great. Lots of work, no UPL letters. But the point is, these innovations are going to become more and more commonplace. And I think that we need to understand kind of where this future is headed. And if we can embrace this, one of the things that Rebecca has been a champion about is getting more people involved. The Rectvisor, when we built it, it's not just judges that reviewed the settlement agreements generated by the software. It was reviewers, legal reviewers, some of whom were attorneys, family court attorneys, but we also welcomed other stakeholders into the process. When we were designing the system, we brought in social workers, we brought in psychologists, we brought in faith leaders, we brought in civic society leaders. So we need to widen the group of people who are sitting at the table making these decisions. And that means a radical expansion, in a sense. If you go to Brazil and you get your bag at the baggage claim, there's a sign over the baggage claim in Rio that says, "How was your flight? If you have a problem, why not file a lawsuit?" And they have a court right next to the baggage claim. And you can go over at no cost, and you can hit a touchpad, and you can file your case, and great, you now have a lawsuit. Now that's, of course, led to a huge backlog of cases. And you will get emails from lawyers who say, "Hey, I'd like to represent you in your case against United Airlines," because in Brazil, if you win your case against United, all the lawyers' fees are covered by the business. And when I say that, oftentimes people chuckle in the United States. And my argument to all of you is, Brazil has it right. We need to 10x or 100x the number of cases that are coming into our processes to provide resolution. And the way to do that is to radically make these systems more efficient through the use of technology. We have to change the way. It's not about a human-powered process. It's about an algorithmic process with human review. That's the way it's going to work with these AIs. And that vision is, it lets us embrace the ideal of the blindfolded woman holding the scales. Because the reality of the system we have now is very, very far away from that. Because most people don't get access to that vision of justice. But by using these tools, we can more realize that vision. And people that are threatened, I think there's a quote from Upton Sinclair that says, "It's almost impossible to get a man to understand a truth if his paycheck is dependent on him not understanding that truth." And I see that playing out again and again. But we need to be creative in embracing the future of the field of justice. And I'm always reluctant to say justice because I'm not a lawyer. I'm still a little fuzzy on what a tort is. But I do believe that justice is connected to procedural, fast, and fair resolutions. And I think we can do a much, much better job of that if we are creative in our thinking.
A tort is kind of like a crime. It's a civil wrong.
It's a harm.
Yeah, it's a harm.
Ralph Nader, right?
Yeah. I think the question for all of us is, do we want to be at the table figuring out what this should look like? Or do we want to just turn it over to others? I mean, I am waiting for the legal TikTok influencers to stand outside 100 Center Street in Manhattan with a portable printer and ask everybody about their case and put the right prompts into GPT-4 and spit out an answer and a jury demand and a discovery demand and file it. I mean, the TikTok influencers can do it if they want to. So do we want to be at the table in figuring this out? This is a really important moment for our profession. Who do we want to be? What do we want to do with the rule of law?
I want to try one more run at a question on ODR, and then I actually want to shift gears and talk about something very different, but still talking about law and technology. So I'll invoke an ALI council member who's right over there. Harold Coe wrote a really beautiful essay in 2021 remembering Chief Justice Gantz of the Massachusetts Supreme Court, and many members here maybe knew him from meetings just like this one. And Chief Justice Gantz, talking about ODR, said the following. He said, "Justice is not only the result that emerges, but also the feeling that someone has been heard." And so the question is, how do we preserve the values of dignity in an online court system? That's one way of thinking about it. In addition to dispute resolution or elaborating legal norms, courts are supposed to vindicate the dignitary interests of the parties who come before them. I could also add that take-up rates in ODR have not been great. Where there have been ODR systems that are set up, people don't really go to them, and maybe that's a referendum that this is not a dignifying or dignified way to resolve a dispute. So what do we think about that? Is that a concern?
I loved Chief Justice Gantz, and I think he was brilliant and a real leader in access to justice. And I think there's no doubt that procedural fairness grows the public's confidence in public justice systems, in courts, in the rule of law. Really important for courts to figure out how to get procedural fairness correct. But please, 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 if you have not walked into a debt collection docket or an eviction docket or even a bond hearing docket, please do that and look at the faces of the people sitting in that courtroom and tell me if you think anybody there feels like dignity is what's happening in those dockets or humanity is what's happening in those dockets. Because it's not. And I also, and I'll let maybe Colin or Becky can comment on it, what we could build in an alternative to an in-person eviction docket or an in-person debt collection docket could build in procedural fairness. It could build it in really well. It could probably build it in better than most humans because, you know what, computers don't get hungry for lunch. And we know that sometimes procedural fairness goes down about 11 a.m. in most court dockets. So I think there's actually lots of upside opportunity for building in the kinds of things that might make people feel like they were understood, they understand what's happening next, something that we think about as procedural fairness.
Yeah, I mean, let me share a few more statistics that we've learned. Pew is funding a longitudinal study of a lot of these court ODR programs across the country, and that's where some of these numbers David refers to came out of. Now, the uptake, these are for voluntary programs that have not been that well publicized, so again, give me a marketing budget, we'll see how we can move those numbers. But some of the other numbers that have come out of ODR programs that are very consistent, about 80% of the cases that are resolved through these ODR mechanisms are resolved at a time when the court is closed for business. So that means late on a weekday or on a weekend, which just makes sense, right? Another thing is 90+%, and I've seen this across many courts, 90+% of the people who go through the ODR process say not only that they prefer it to the face-to-face option that they have, but also that they would recommend it to a friend or family member, which is an interesting proxy for procedural justice, because it's not just about my case. Someone I love, if they had their own case, I would recommend that they go through this process. You know, a good friend of mine is a woman named Jean Sternlight at the Saltman Center for Dispute Resolution at UNLV School of Law, and she's an expert on the psychology of dispute resolution. And she wrote a great article called Pouring a Little Psychological Cold Water on ODR, which I highly recommend. And she and another professor, Robert Conlin, who wrote an article called ODR Stinky, Repugnant, or Drab, which I think is a great title. But again, we need to listen to the critics of these processes. One of the things that they say, and I think this is 100% right, you can have the best AI in the world that goes and looks at 10 million cases in 20 different languages, and it does all this analysis, but it's a black box, and then you come back to your landlord-tenant case, and it says the landlord should pay the tenant $362.28. And the parties don't have any idea why that's the right number, and they don't feel any closure at all. And what Jean talks about is, we talked about this in the Rectvisor too, the creation of a justice journey, where people have to go through the emotional process of negotiating a case, feeling like they're heard, feeling like they got procedurally all of the appropriate steps. And I was just the foreperson of a criminal trial in San Jose not a couple months ago, and I realized at the end of the process, the reason why it was so ornate was because it was really for the offender. It was obvious. We knew what the outcome was, but all of these steps needed to say, look, the process was done, justice was done. And if we just build these systems, and I think Colin talks about it's just checkboxes. You click a bunch of checkboxes on a site and you hit generate and it gives you an output. You have not gone through the justice journey for that party. And that person is not going to feel closure. They're not going to feel like they had a fast and fair resolution. So again, to me, that's a systems design problem. And I think there's a lot of ways that we can design these systems to meet the needs of parties, even those who can't read. You know, we can design processes that work for them. So.
All right, let me shift gears for everybody now. We've talked a ton about ODR. That's a system that a court might implement to actually find some alternative way of adjudicating cases. But there's an alternative out there. It's another really important tectonic shift with really big implications for the way our courts work and for the legal profession. We don't necessarily have to build a different way of adjudicating cases. Maybe we just need to find better ways to get people legal help. And that implicates, you could call it a movement, usually travels under the label regulatory reform or reg reform for short. It's a terrible piece of political sloganeering, but there it is. And this is the movement among states to relax the usual rules that say that only lawyers can practice law or only lawyers can own law firms. So think UPL and Model Rule 5.4. In order to empower and welcome new types of legal services providers into the system. That might mean human non-lawyers. So you're maybe aware that there are lots of efforts to think about how we might bring in paraprofessionals along the lines of like a nurse practitioner or a physician assistant, a non-lawyer with specialized expertise in a particular area. That's half of reg reform, but the other half, and maybe the larger half in the view of many, would be relax those rules to welcome non-human non-lawyers into the system, which is to say software-based legal services. Bunch of states, well, 2 states have done it. Utah and Arizona, to varying degrees, have relaxed those rules in order to do that. Many other states are considering it, among them Michigan and Texas, so these are big legal markets. Opponents, of course, say we should really be worried about that. We do that at our own peril. And they often invoke a phrase, corporate practice of law, the practice of law by entities owned by non-lawyers, where services are delivered by non-lawyers. But there's a pithier rallying cry as well, and it is as follows. It's 2 words, Google law. Should we be worried about that? That's an alternative way to do this if we have millions of people in the system who can't get good legal help in order to defend against lawsuits. Should we open up the system to new types of providers? And what do you think about the specter of Google law?
I'm so glad that David defined the corporate practice of law for me, because what I thought it meant was you have a really big organization with thousands of employees and offices around the world that provides a service for money. But apparently that's not what it is. It's not DLA Piper or whatever, right? It's when somebody who's not DLA Piper makes money from this activity. I don't see any reason, and I welcome pushback, I don't see any reason why that's a threat to access to justice. The current threats to access to justice are the legal profession's monopoly on the law, which creates not just a very constricted set of opportunities for people to get help, but incredibly expensive and exclusive pipeline of access to the opportunity to participate in the law. It's not a 3-year degree, it's a 7-year degree. And you're gonna come out with hundreds of thousands of dollars in debt. Not everyone in America, not every group in America has access to participate in justice in that way. And so if regulatory reform, whether it's relaxing UPL in different kinds of ways or allowing outside investment that might allow even traditional law firms to do things in different ways, can open up some of those doors, I think we should try some of that.
Oops. I hit a second button. Can you still hear me? Okay, good. Honestly, I think the bar's resistance to relaxing those rules is one of the moments that we should be least proud of. And every one of us should be doing everything we can to work on this issue in our home jurisdictions. Lawyers, it's so weird. Do you ever hear doctors call people who are not doctors non-doctors? We say non-lawyers all the time. That's a completely comfortable term. We've even trained people who are not lawyers to say non-lawyers. It's so weird. I think these numbers are right, Becky, you'll correct me if I'm wrong, but in healthcare, 11% of people who provide healthcare services have an MD or a DO. Everybody else who provides healthcare services does not have an MD or a DO. And as you know, lots of times, the answer to your particular ailment, you don't need an MD or a DO, hardly ever, in fact. Lots of other healthcare providers can provide it to you. Legal service providers, 80% of them have a JD. Wow, how does that make sense, given this enormous market failure that's right in front of us?
All right, one more round of this. Here's a question that maybe ties together what we talked about with ODR and what we just talked about with respect to reg reform, this idea of relaxing these rules to let new kinds of providers into the system. So, you know, I'm a Stanford Law professor, so I occasionally take a pitch from a legal tech company if I think I might learn a little something about what's going on in this space. And I heard a pitch a couple months ago, and it was a startup that was developing a tool for eviction defense. And they took me through it, and it was a super sleek platform, really easy to use, plain English, multiple languages beyond that. And it helped an eviction defendant to generate an answer. And then they started showing me other aspects of it, and they said, you know, we think we can also generate something like a prediction as to how the case would come out. So they're building out a part of it that they are not implementing just yet, but that actually provides automated software-based legal advice to an eviction defendant. I said, wow, that's great. First of all, you've got a little bit of a regulatory problem there, if that's where you're really going with this. So you're gonna need a relaxation of the rules in order to make this happen. But then more importantly, I said, talking about a set of customers who have very limited ability to pay. By definition, they have very limited ability to pay. So how are you going to make money? And at that point, they started to look a little bit sheepish. And they said, well, you know, we see eviction as a two-sided problem. And once we're done with the defense side of this tool, we're going to start building out the landlord side with a similarly sleek interface, user interface, and even that automated advice as to what the legalities of a particular case are. And I said, oh, you're just building a private ODR system. At which point they said, no, we're not doing that. But that's exactly what they're doing. They're building a private ODR system, and they're building a private court system that will compete with public courts. Now, they need some regulatory reform in order to get there, in order to do all the things that they want to do, to provide all the services that they want to do on this platform, but that's where they're going. Now, I like this question because it's no longer about Google Law. It's no longer about Google or some large entity providing legal advice to individuals. Rather, it's like Google Court. You can call it Google Court because it is an entirely separate adjudicatory scheme that in an automated way provides legal advice to people. It's an all-in, one-stop shop for the adjudication of disputes. Do we worry about that?
So going back to that horrible phrase, regulatory reform, one of the models that's being applied to that, to legal services provision in the United States, is the one in Utah, which goes under another horrible name, a sandbox. So, which is a term that comes from fintech, and the idea is you admit entities that want to do wacky things that violate UPL or 5.4 or both, And then you watch them. They have to provide data about actual consumer experience because that particular experiment is designed to regulate for one thing and one thing only, which I would argue is the one thing, which is consumer protection. So what you're measuring is, are consumers harmed by these services in very specific ways, and we have very specific ways of measuring them. There's no reason you couldn't do that with alternative adjudication systems. There's no reason that we couldn't try these things and monitor them very closely. And to the extent that they're online, it's like gravy train dog food from the 70s. They generate their own data, right? So it's not like you have to go to, in Utah, we have to go to human providers and teach them what data are and how to collect them and how to report them in a consistent way. But in an online system, it's already doing that. So I think it would be very easy to have some experiments and see if this would be better or worse or just different.
Well, one of my heretical tenets of ODR systems design is I don't think complainants should pay filing fees. I think filing fees make no sense. If I have been victimized, if I've been aggrieved, either in a marketplace or by a tenant or something, why should I pay an additional fee in order to get redress in that case? And if you look at the way it works in Silicon Valley, pretty much all collaborative economy companies have built their own justice system. At eBay, we call it the Resolution Center, and it's buyer-seller disputes. But at Airbnb, they have a process as well, also called the Resolution Center, and it's host and guest disputes. At Lyft and Uber, it's rider-passenger disputes. At Upwork and TaskRabbit, it's contractor-contractee disputes. And guess how much people pay to get access to those redress systems? $0. Now, why? Who's funding it? Well, it's the internet intermediaries. It's the marketplace administrator who's making a lot of money. And the way we thought about it at eBay was we took 1/10 of 1 penny out of every transaction and we put it into a fund, and we said, this is going to fund our resolutions. And it actually covered the cost of resolutions because only 1% to 3% of transactions generated a dispute. And as I said, 90% of those were resolved in software, so it was very cheap. So I think we need to think about a future where, even when I look at the courts and I think about how many fees are charged, when I was trying to start some of these court ODR processes when I was at Tyler with Modria, I would say, can we get $25 maybe out of the filing fee? And they'd be like, no, all that money is already spoken for. So you have to charge a new filing fee. And it's like, wow, okay, this is tough to charge these parties additional fees because they can, they're in bad situation to begin with. So I think there are many creative ways. A lot of the industries that are generating these disputes are making billions of dollars, but they're also generating disputes, and they're not paying for the resolution of those disputes because those profits, it's like an externality for the organizations that are actually making the profit. I think one of the things I like about online dispute resolution is you can integrate the resolution process into the transaction environment itself. So the profits being generated by an overall ecosystem or a marketplace, you take a portion of that and it funds the resolution process, and that actually makes the marketplace run more efficiently. So we need to internalize some of these externalities, and I think it's a more creative funding model than this notion of saying, well, aggrieved parties, you have to cover the costs.
All right, we have a little time left. Let's move to open mic flash round. I've been pretty directive so far, walking through ODR, and then in turn walking through reg reform. So I guess one question, maybe this can just be a quick flash round. It looks like there may be people who have some questions. So why don't we do this as a flash round? If you've got something in mind, what most keeps you up at night in this space broadly defined, technology and access to justice?
Two things, lawyers' persistent, evidence-unbased conservatism. The behavior of the legal profession is an enormous obstacle to justice. That keeps me up at night. And the other thing is, and this is not particular to this space or any particular space, the obsession with the new and the wish to believe that it's going to change everything, which I think is a testament to our capacity for hope, but it also keeps us from thinking about systems. So you're changing one thing in a thing that has lots of interrelated pieces, and that's going to have all kinds of consequences that you can't see if you're only thinking about that one thing.
There was a time at eBay and PayPal when we were the most defrauded site on the internet. There were people who went to work every day in suits and high-rises with computer science PhDs, and their jobs were to defraud our users. And we really saw it as an arms race. Because when new tools are invented, the bad guys don't hesitate to use them. And what worries me is the good guys who want to use these tools to do well. We sit around at meetings like this, well, we don't know what to do, and maybe we could loosen this regulation, and the bad guys are going light speed. So this is an arms race between those of us who want to use these technologies to do justice and those people who want to use these technologies to do injustice, and I worry about the inaction of the good guys.
It stinks to go last because what Becky said and what Colin said. I think that I have an article coming out, by the way, that's titled Remote Hearings, Why Do Lawyers and Judges Hate Evidence? The unevidence-based nature of so much of our very strong feelings about what we do is really a problem. But I think in addition to the way you described it, Colin, the bad guys get ahead, I worry that our inability to really do things collectively as a profession and to include people that we need to include to do it right is going to keep us from catching the bad guys.
All right, we have a little chunk of time. Should we do questions? I didn't even realize we were going to do a QA thing, so maybe that makes me a bad moderator. But yeah, microphone one.
Brian Garner, Texas. 3 quick points. Perhaps the most hypocritical of all legal maxims is the law abhors delay. And there are many iterations of that. Delays in the law are abominable, et cetera, et cetera. It's always kind of surprised me that Rule 1 of the Federal Rules of Civil Procedure does not provoke guffaws when it refers to speedy resolutions. And this really could solve the problem, because a lot of that problem in a big way, because a lot of defendants, if we can generalize, a lot of defendants really like delay, and delay is value to them, and delay lowers the value of plaintiffs' cases. And so I think perhaps this could overall have the effect of upping the value of plaintiffs' cases. A second point is that if you get competitors, presumably Consumer Reports will be reporting on which of these software programs will give the best results to a certain type of litigant, whether it's a renter or a landlord, that sort of thing. And we'll soon have reports. And it'll be possible to have several of these different softwares run and find out the range of what the likely results would be. Third, it seems to me that Big Law will use this software or this technology for the purpose of doing moot courts, mock trials, and finding out what kinds of things can you put in that would, even in a bigger case, result in a better result for the client. And as you were talking, every time you talked about humans getting involved in the situation again, I had a sinking feeling. Oh no, and delay again once you get humans involved.
Great. Let's take one more question over at 2, and then maybe a response, and then ideally there'd maybe even still be a little time to take more questions. So David.
Yep. Levy, New Mexico. I wonder, Bridget, if you could talk about during COVID, when the courts were pivoting in these really consequential cases like housing evictions. My understanding is that all of a sudden, instead of defaulting, people were really showing up and they were participating, and I think that's very important.
Yeah, so there's not great data, but there is data from jurisdictions across the country about the number of people who defaulted when they were given a remote option to appear, and self-represented people in particular is who I was mostly focused on and worried about, and that's actually what this article I have coming out in the Litigation Magazine is about, that we now know that far more people show up to a hearing when they're given a remote option than when they have to find transportation and park and find childcare and go into a scary building, which courts are to a lot of people, and yet many courts are not doing them anymore. Why do we hate evidence so much?
Sorry, 1 and 2 again. Should we take 2 questions and then maybe have a response?
Craig Isco, Washington, D.C. I just wanted to echo the points just made. There are certain kinds of cases that don't lend themselves to any kind of alternative dispute resolution because the plaintiffs and landlords or debt collectors want to rely on the enforcement mechanism of the court. And so they have to go through that. And that's why I think remote participation is so important, because for all the reasons Judge McCormack just mentioned, people can't show up. They risk losing their job. They can't take care of child care. Or there's 100 people at a cattle call at 9:30 in the morning, and they have to wait till 2 o'clock for their case to be called. It's why we need to really work on remote representation and scheduling of perhaps particular blocks, some at 9:30, some at 10, some 11. There are other things also, but a limited representation rule can be quite effective as well, that lets an attorney step in on that particular moment and provide some advice, but not be obligated to remain. And finally, to the points that have been made, the ChatGPT and all of these things we've talked about can be very helpful to self-represented parties. They can also delude the judge, and as a judge I appreciate that, with lots of things to deal with, but it will help them frame their issues much better and far more effectively represent themselves.
Thank you. Harold.
Harold Koch, New Haven, Connecticut. I think that the panel shifted away from what I thought was the crucial issue, which is to what extent is shifting to these online or computerized mechanisms exacerbating existing discrepancies of power and access. And the issue there is not whether technology would help address efficiencies, but what is the limitation on the removal of human judgment from the decision-making process? And I think it's quite unfair to Owen Fisk, my colleague, or to Ralph Gantz, my friend, to suggest that they were right before, but the mechanistic view is right now, because what kind of eviction process do we have if there was no human decision in Javins? Or what kind of prejudgment seizure provisions if we have, would we have if we didn't have Fuentes versus Chevin? There is a critical point at which norm enunciation by a human being comes in and then shapes the future of thousands and thousands of cases that are decided mechanistically along with these principles. But if there's a role for the American Law Institute, it's to isolate where human judgment is absolutely essential and cannot be removed from mass processes, because to do so would be to substitute mechanistic dispute resolution for humane justice.
Yeah, I think we're going to take two more with apologies to number 2 and 3 in line at microphone 2. So a similar situation. Let's start with 1 and then move to 2.
Thank you. Ramo, New Mexico. I want to make a broad point about how the law and lawyers are regulated, and a smaller point about my concern about the use of some of these things in a very negative way. The broad point is you're exactly right. Lawyers are licensed and disciplined and governed state by state. And just as when the American Law Institute was founded because we suddenly had railroads and telephones and highways, now we have to look, I think, in a very different way, because we, not so suddenly, but have now not only interstate, but global practice of law and clients, and the current system is simply not set up to either license lawyers for those things, and maybe there should be a different license, and it is absolutely not set up to regulate the practice. And so one of the things that you focused me on is to go back to the American Bar Association, which I have had some experience with, to say, and actually I wrote the first book for lawyers on systems analysis in the 70s, and I think that's important. I do think, though, that we have to worry about the oppressive use of some of these things. There was a very good American Academy of Arts and Science, in fact, one of your colleagues was involved in this, about access just maybe last week. And just as you said, they used, I don't even think it was 4, just GPT-3, to do a perfectly wonderful complaint in interrogatories. And what worried me is that either an out-of-our-country state actor or a bad person can harass people by filing multiple terrible lawsuits in about 2 seconds. And what Judge Gonzalez comforted me about this, as I've been worrying about this for a while, is, well, there are filing fees. And so I do think we have to think very hard about how to increase access and at the same time make sure that this new technology is not used in the most horrible way, which we've seen in our country now, to harm people. And suddenly you wake up and you've got 7 liens against your house and you never borrowed $1. So I think we have to be equally concerned about that. Finally, let me just say something about the human touch and what makes people feel they have justice. I think, Colin, it's different when you buy something on eBay or Amazon than when you have some of the life-changing things that trouble you. And that's where I think Harold is right, and we need to be very thoughtful about this. I learned something from my husband, who's a cardiologist, a long time ago. We don't teach bedside manner in law school. And I used to get notes from people when a patient had died, and the family would write me a note and say, when your husband came to tell us what happened, he had tears in his eyes, and you will never know what that means. And all of us who practice law and many judges understand that part of what has to happen to make people feel that they've had justice has not just to do with the process, but to do with how we treat the people. And I don't think even GPT-10 will have the hands-on thing that a great lawyer can do for a person.
All right, last word, I suppose.
Thank you, and I'll try to be brief. Christine Durham from Utah. I've had the pleasure of working with Becky on our sandbox process, and I chair our Access to Justice Commission. And one statistic that I didn't hear, although I might have missed it, is that when the board for the sandbox, on which I sat for a little while, was evaluating the quality of services that people could receive through applicants to the sandbox, I think it was Becky who usually reminded us that these are people who will have no access to any form of support. I mean, the latest statistics suggest that somewhere around 85 to 90% of Americans have no access to legal services. So when we're talking about alternative methods of delivering support and help, we have to measure it against that statistic. The other point I wanted to make, and again, it was something I didn't hear when you were talking about the things you worry about. Rebecca's done a really interesting article pointing out, for example, I mean, we're trying to build our sandbox process, but the uptake is slow. We haven't figured out how to make any money from it for regulatory purposes, and as you know, regulation is expensive. I used to be a member of our Supreme Court, and my theory is we should be able to go to the legislature and say, Constitution says we have to regulate the practice of law, give us the money to do it. But they're not amenable to that notion, not surprisingly. And the lawyers who, through their fees, support the regulation of traditional practice of law also have not been over-enthusiastic in their desire to make this possible. So one of the things I worry about is where are we going to find the support and the money? I know other states do a little bit better in supporting access to justice. Our state does not, and I think the majority of states do not. So thank you.
Will you all please join me in thanking me? We will be talking about this all day, all month, all year.